One of the more striking revelations in this New York Times op-ed is that members of the president's own cabinet discussed removing him from office. There were whispers, was the word used, of removing the president under the 25th Amendment. This anonymous senior Trump administration official writes, given the instability many witnessed, there were early whispers within the cabinet of invoking the 25th Amendment, which could start a complex process for removing the president, but no one wanted to precipitate a constitutional crisis. President Trump tweeted a response to the op-ed with one word, all caps, treason, question mark. But what exactly is the 25th Amendment, and specifically this Section 4? Let's talk to Barrett Berger. She's a former federal prosecutor and the host of Law and Crime, Bob Bianchi. So Barrett, let me just start with you. As I was reading about Section 1, 2, 3, it's the fourth section that's key on the process of removing a president. Can you spell that out for all of us?
Sure. So this is kind of new territory. The fourth section of the 25th Amendment, we've never actually seen this used before. Right. So this would be fully new territory. And this is relatively recent. So this was only ratified in 1967. So this is really the section that is for if a president is incapacitated or can't carry out his or her duties. This gives us a procedure for the vice president and members of the cabinet to really alert Congress to say, to give a declaration saying the president can't fulfill his or her duties. There's then the chance for the president, if he disagrees with this, to submit his own declaration saying, wait, I actually can. And then this would have to go to Congress. They would have 21 days to make a determination as to whether or not the president actually could fulfill his or her duties.
Stand by. I'm being told we're going to actually listen in to the Judge Kavanaugh hearing that is still underway. This is day 3. This is the man who this president would like to become the next Supreme Court justice, getting grilled up on Capitol Hill. Let's listen.
Let me be clear about the point I'm trying to get to.
Okay.
It's your views about whether or not, when President Nixon fired Archibald Cox, he obstructed justice in violation of the Constitution, or the firing itself violated the Constitution. It's important to know your views on U.S. v. Nixon as well, and we'll turn to that. But I'm interested in your understanding of the Constitution and whether or not it prohibits restrictions on the president's ability to fire a special prosecutor at will.
So the Supreme Court said, and so you're asking my views. My views are what the precedent says. In other words, I follow the precedent. The precedent of the Supreme Court in the U.S. v. Nixon case did apply that regulation, analyze this. And
Judge, U.S. v. Nixon was unanimous, correct?
It was unanimous, 8-0.
Are you aware of any justice having questioned the decision in U.S. v. Nixon since then?
No, I've called it one of the 4 greatest moments in Supreme Court history, U.S. v. Richard Nixon.
You have, and that's exactly what I want to get to, because you've also, in another context, as we talked about yesterday, in a roundtable in 1999, volunteered unprompted that maybe Nixon was wrongly decided. Do you think U.S. v. Nixon was wrongly decided?
I've said it was one of the 4 greatest decisions and correct decisions in terms of the specific regulation at issue in the case, and the court's holding in the context of a criminal trial subpoena, that the subpoena for the information, the tapes, was enforceable in that context. And that's what I've said before publicly about the Nixon case. And
so,
that
Judge,
1999.
You would agree that it was correctly decided? Did I just hear you right?
Yeah, of course. When I say it's one of the great, I mean, when I say something's the greatest, that means I agree with it. And the point was, under the specific regulation at issue in that case, a criminal trial subpoena for the information. And it was a moment of judicial independence, a moment where the court, I think, came together as a unanimous opinion written by Chief Justice Berger. So that's an important moment in the court's history.
So you'd agree, then, just following the U.S. v. Nixon precedent?
Okay, so let's come out of that. And Bob, let me come to you, because they're talking about U.S. v. Nixon, and he was saying it was one of the 4 greatest decisions the Supreme Court ever made, unanimous 8-0, which basically meant that they had to hand over the tapes and subpoenaed materials to the court. Can you talk a little bit more about the significance of that and what why this moment really matters.
Yeah, sure. This is hugely significant because there is an issue right now with the Mueller investigation. To what extent, if he is made a justice of the Supreme Court, has a swing vote, he would rule with regard to what level of oversight does the court have in order to compel things that are subpoenaed. And this is not the first time; it's the second time that Judge Kavanaugh has indicated that he believes that the president, with a lawfully issued subpoena, would have to respond to it, and that he's not above the law. So, Brooke, this gets to, is the president going to be above the law, be able to scuttle investigations, be able to withhold and hide evidence? And he's basically calling this one of the 4 greatest decisions that was written because it's the check and balance on the president. Whether he does that when he gets in there, we don't know, but that's what he's saying right now.
Look, I think one thing that's important to note, though, is when he was giving his answer, he said it was enforceable in that context. And I think that's very important. I don't think this is somebody who uses his words lightly.
Is that giving him wiggle room?
I think it is. I think he's being very careful and probably very deliberate in using those words in his answer.
So if it were to, so as he's being asked about the president's right, I mean, if it were, this is all in the land of hypothetical, the right to fire Mueller, subpoena the president. That's what all of this really, the meat of this comes down to.
Absolutely. And of course, there's a big decision here as to whether or not we would call it obstruction, influencing or impeding an investigation by firing those who are returning significant indictments. And this investigation is not just of the Trump administration. It's about Russian collusion. So he may be asked at some point in time, Justice, what is your opinion or your ruling with respect to whether the president, much like what Nixon did, just fires people who may do things that they think are antithetical to their interests, thereby scuttling the investigation. Me as a prosecutor, can you imagine I'm in the middle of a murder case and somebody has the ability to say, I don't like what Bianchi's doing here, you're fired. I mean, this is not the way our rule of law is. What will he do?
That's why these questions matter. Barrett and Bob, thank you so very much as those hearings continue.